counsel. Justice Thomas? Justice Alito?
You say that there is not a problem with, at least I understand what you're saying, there is not a problem with prohibiting everybody who is addicted to a controlled substance from possessing a gun. Is that correct?
We do not have a problem with that.
And that applies to everything, every controlled substance. So that would...
I think the concept of addiction, the determination that's made to show that someone is addicted to something is, I understand, the kind of determination that's going to show that somebody is engaged in the kind of use that renders them a risk all the time. So I just want to be very clear about, we're not conceding at like some generic level. It's because the concept
Seriously, you think that being addicted to every single drug in the schedule renders that person a danger? You would be willing, you don't think arguments can be made that being addicted to, I don't know, the illegal use of Ambien?
I'm not sure you'd be able...
charged with that person couldn't come in and say, whoa, that doesn't make me dangerous.
Sure,
I'm doing this while I'm sleeping.
And this is where we might have a marginal disconnect about, when I think of what would be necessary to prove that someone's addicted to something, it's going to incorporate something like the definition of the Controlled Substances Act that's asking about whether you are a threat to yourself or others. And maybe there's some substances you just can't make a showing that somebody's addicted in that sense. But if you accept
Can an addict, as to every substance in the list, insist on an individualized determination or not?
The statute requires that. I mean, you
so
can't
there has to be an individualized determination. So the mere fact that someone is addicted to something that is a controlled substance is not enough for Second Amendment purposes.
I don't know how you determine that someone's addicted to a controlled substance without engaging in an individualized inquiry into their use. Once you've determined that someone's an addict, you've determined that they fit into...
Not as to their use or even their reason for the use, but whether their situation renders them dangerous.
I mean, that is what the definition of addict in the Controlled Substances Act contemplates, that you have to assess somebody's use by reference to the impact it is having in their life. So I don't think it works under the statute to say someone's an addict without having engaged in an individualized inquiry into the nature of their use. And that's what's required all across the country. If you want to adjudicate somebody a drug addict who can be subject to confinement or guardianship, you have to actually individually assess their use of the drug and the impact it has on their life.
I'm sorry, you finished?
No, go ahead.
Yeah. If an individualized determination is required under G3, is it an individualized determination as to that particular individual, or is it as to the drug across the board?
So I think the individualized inquiry is to whether you are addicted to a controlled substance.
Well, no, I'm not talking about addiction now, just use. Whether someone is prosecuted for being a user of drugs.
Sure.
And you say you can't do that, you have to have an individualized determination as to something. And what is this thing there must be an individualized determination?
I want to be clear again. We are not actually saying that the only way to do this is through an individualized inquiry. For addiction, I think it is, because I think the concept of addiction requires it. But if the government wanted to say that there is a particular degree of consumption of a particular substance, that it considers virtually anybody who consumes in that quantity to be someone who cannot possess a firearm. We are not asking you to rule out the possibility that the government could make the showing that that category is categorically analogous to the concepts that the habitual drunkard laws reflected. We are not saying the only way they can do it is by coming in and making a case-by-case determination. They can proceed either way. It's just that if they want, whichever way they want to do it, they have to meet their burden under Bruin of proving that they did, in fact, make the right determination. They put either the person or the substance use into the correct category.
I struggle to figure out how these individualized determinations can be made in the context of a criminal prosecution. The way in which criminal prosecutions are conducted makes this extremely difficult. Now, the Third Circuit issued a very thoughtful opinion about what they thought is required in an individualized determination. And what they said was that the test is whether disarming a drug user is needed to address a risk that he would pose a physical danger to others. Is that the test that you would apply?
That's not necessarily the test. We would ask you to apply a test more akin to the historical one, but
Well, okay, what is it? What is your
Sure,
test?
the test is whether somebody's use is rendering them unable to function in their day-to-day life all the time, whether it's because they're always intoxicated or because their use is such that it's impairing their ability to function in their day-to-day life. That is what the civil commitment laws asked. They said, is someone a drunkard incapable of taking care of himself or his property? Or you had to prove that a person, by excessive drinking, is unable to attend to business or has lost self-control. You had to prove these things.
I'm just puzzled by most of your argument. Suppose somebody, I just don't understand what you're arguing for. Suppose someone regularly takes a drug, and during the period when that person is taking the drug, that person is super dangerous. Congress couldn't, the Second Amendment would not permit Congress to say, that's too risky.
It might, and if you look at the laws, the definitions that were used historically, some of the cases talked about it in terms of, is somebody the type of person who's going to take the substance, going to drink to excess whenever the opportunity presents themselves? They're focused on that question of saying, not just, are you always drunk? But are you so habituated to it that you are drunk a lot of the time and we can't trust enough for you to just, be around the one day a week? That's why we're going to commit you or have guardianship or have these severe consequences. And so we don't think, the traditional way the addiction prong is applied is to give juries the instruction from the CSA definition, which requires a jury to make an individualized finding about whether somebody's use is impacting.
All right, well, speaking of jurors, these are the factors that the Third Circuit said an individualized determination should entail. The length and recency of the defendant's use during and shortly before his gun possession. The drug's half-life, whether use of the drug affects a person's judgment, decision-making, attention, inhibition, or impulse control, whether the drug may induce psychosis, the drug's interference with a user's perception of his own impairment, the long-term physical and mental effects of the use of that drug. Are those, in a criminal case, would those be submitted to the jury?
We are not suggesting that juries would need to be instructed to consider all of those things, but I certainly think the government would say that's the type of evidence we should be able to present when we want to show that a drug was correctly categorized
So experts would testify on all of these matters, and the jury would decide whether the person met the test for being a dangerous person?
I don't think the government's going to need to do that when it comes to a lot of cases and a lot of substances.
Well, maybe not always, but if that's at issue, is that what's going to be required?
Again, the government can't even put a substance on one of these schedules without having to withstand if somebody wants to bring a challenge to that. They're going to have to prove it up.
We're talking about criminal prosecutions and what needs to be shown in a criminal prosecution. I don't know where the Sixth Amendment line is as to all these things. But even, let's assume that some of them, all the ones that go to questions on science, for example, you would have every single district, potentially every district judge in the country would make a finding. And I find, as all of these drugs, I find that the use of this drug, that users of this drug are dangerous or they're not dangerous. Every district judge before whom that issue comes up would make a determination on that scientific question.
No, I think you can give the jury a standard that asks whether somebody's use is impairing their ability to function, and the government can then choose to present evidence. They can present evidence about their life. They can present evidence about the nature of the particular substance and the fact that it is a substance that carries with it effects for days at a time. It can present evidence, and the jury can make an ultimate determination, just as the jury has to do as to the addicted person.
It's been said that Congress never made a judgment about the dangerousness of using all of the substances on the controlled substance list. Is that right?
I don't think Congress has made a determination that anybody who uses those substances regularly is a public safety risk.
Isn't that what Congress did when it enacted G3?
No, because Congress only applies that if somebody's use is unlawful, and so somebody can be using a controlled substance regularly under the Controlled Substances Act, and Congress deems them not to be a public safety risk so long as they got the prescription for the sleep aid and they aren't the spouse who didn't.
One final question. In The cases in which we have previously held that the Second Amendment prohibits certain government regulations, Heller, McDonald, Bruin, there have been a lot of the sky is falling arguments about the consequences of that for public safety. In Rehafe, I said that I think that 922G has a more direct and severe bearing on public safety than the issue of whether a law-abiding citizen can possess a gun in the home, or even, as in Bruin, carry the gun outside the home. Do you disagree with that? Here we're
No.
talking about disabling people like people who have committed felonies.
Sure, but I would note that under 922G3, it's only about 5 prosecutions that are under G3. The vast majority of them are under other provisions, and about 80% are under G1. So I don't think the arguments that we are making today would vastly endanger the government's prosecutorial efforts under 922G.